about recent developments with respect to insider trading in last 1 week, and there has been no week where I had not shared more than 2-3 important news or pronouncements or amendments. So with this pace, PIT is getting matured. So this week, on 6th of July and on 8th of July, we saw some orders. On 6th of July, we saw a very unique order where there was one company called FDSL, which had dealt in the shares of Rico India. And they had made a profit of around 1.13 crores and saved a loss of around 1.16 crores. And SEBI wanted to pass a order, impounding order, uh, uh, which will disgorge the profits made and the profit loss saved. And that order was about to be passed on FDSL. And in that course, SEBI realized that FDSL is already under IBC, and therefore they are under CIRP process. And obviously, as the law stands today, any regulator's claim can be at the last in CIRP process. And therefore, they chose to lift the corporate veil with respect to FDSL, and they have passed a penalty on its managing director, who is Mr. Amalendu Mukherjee. So this is a classic case where SEBI has levied penalty not only on the insider company who dealt in the shares, but all actually lifting the corporate veil. And there is a detailed and elaborate discussion in this particular order where you can see about lifting of corporate veil. So this is one classic case where SEBI has lifted corporate veil and passed an order. Just to remind all participants, this subject that SEBI is concerned that with respect to the penalties which are getting imposed by SEBI on the companies, if those companies go into IBC, what will happen to SEBI's claim? And SEBI, in its very recently, Justice Dave Committee reports submitted a report on this subject also, and in that they have submitted that SEBI's claim should be a priority over all other claims, and this should not be impacted by notwithstanding or non-abstante clause mentioned in IBC. So in line with that and without waiting for that amendment to be passed in IBC, SEBI has lifted a corporate veil in this case and penalized individual director. In Dynamic Technologies case, which I had shared maybe 2 weeks before, where a managing director was held responsible for the loss saved of around 3 crore rupees, and then impounding order was passed. And immediately he approached SAT, and SAT has set that order aside, saying that it is COVID-19 scenario, and why is there compulsion for SEBI to freeze the accounts of that managing director, particularly in this scenario. So this is a little offbeat order. And then in Manappuram, this case we have been discussing since Ambit settled the matter with Ambit as an intermediary, as a research analyst, when they were shared some information by Manappuram. And Ambit had shared that information with their clients, who were close to 2,000 clients. And that was leak of UPSI, which Ambit had done as a SEBI intermediary or in a fiduciary capacity, for which they settled with SEBI at 6 crore rupees. Subsequently, in probably last Friday, we also discussed about settlement of order, which was done by compliance officer, CEO, managing director, ED, and one of the directors of Manappuram, where they settled each 15 and half lakh rupees. And now in this week, that is on 8th of July, we saw an order where Manappuram settled the matter with SEBI for leak of UPSI, and they settled at rupees 2 crore. Now this is, I am little curious to see the big difference between leak of UPSI on the listed company, which was 2 crore, and leak of UPSI on the SEBI intermediary and fiduciary as 6 crore. Why there is such a high difference? Prima facie I have not been able to gauge that, but as soon as our research is complete, we will get back to you on these details as to why this such a huge penalty is levied on SEBI intermediary, and why very less penalty is levied on the company. Now, I will share with you today's PPT. Uh, Are you able to see this PPT?
Yes, I certainly can.
Yeah, thanks. So this today's subject is with respect to designated persons and compliance is related to that. So designated person, we have to discuss with immediate relative also because that goes hand in hand. And just to give a brief background of some of the participants who might not have attended all earlier sessions, we so far so good we had 10 sessions and this is the 11th session, out of which first session and seventh session, eighth session, ninth session were predominantly on UPSI. First session was on what is UPSI. Seventh session we compared UPSI versus generally available information with the help of
Excuse
various
me.
pronouncements.
Just 1 second, Makan.
Yeah.
Thank you. She's done it. She's closed it. No problem. Please carry on.
Thank you. So on seventh webinar, we discussed UPSI in comparison to generally available information. And in all these sessions, some of you might be attending regularly. So they know that we have been discussing in the context of SEBI pronouncement, SAT pronouncement, Supreme Court pronouncement sometimes. And from that context, we have been trying to understand what SEBI's mindset is. So 4 occasions we discussed about UPSI. Webinar 8, we discussed what is UPSI and when UPSI comes into existence. And we laid down some important principles about when this UPSI comes into existence. We discussed that from the context of financial result, from M&A context, from investment context, from regulatory action point of view, which information is considered as UPSI, which is excluded from UPSI. When SEBI said that this UPSI has started, all of those principles we discussed. And ninth webinar, we discussed some case studies, applied all those principles to some hypothetical cases, and then we discussed about that. Webinar 2 to 4, we discussed about role of CO, that is compliance officer, in the context of UPSI, in the context of monitoring and disclosure of trade, and the policies, procedures, and mechanisms. So this policy, procedure, and mechanism also was a very interesting discussion where compliance officer's role in that context we had discussed. Webinar 5 was particularly with respect to debt listed companies, and some participants who might have attended at that time, they will recall some of the interesting nuggets which we derived in that discussion. And subsequently, even in pledge, there were a lot of interesting insights from informal guidance which was issued by SEBI with respect to Gitanjali investments and also with respect to Binani Industries, and why there is a difference, why there was a difference between two informal guidances, that also we looked at. In the last session, that is webinar 10, we discussed about PIT applicability for fiduciaries and intermediaries. So little moving ahead, moving away from listed company and listed company compliance officer domain. We looked at what does PIT means for all of us, for all company secretaries, chartered accountants, merchant bankers, lawyers, and whoever deals with UPSI of a SEBI listed company. And today we are going to discuss about designated person and immediate relative. The first question in this discussion, now I am going to discuss this subject in the context of from considering that the audience is compliance officers, not considering that audience is designated person. Had this been an audience of designated person, drastically the language and the content would have got simplified. So I am talking this from the context of a compliance officer. Who decides who is a designated person? So obviously board of directors decides in consultation with compliance officer. And what are the parameters? We all know that role and function of that individual or that body in organization, and with respect to their access to UPSI, whether they have particular UPSI or not, that's a different story, but whether they have access to UPSI and what is the role and function and what is the seniority and designation. These are some of the parameters which compliance officer is expected to apply and then suggest his list of designated persons to the board, and board will have to approve it. With respect to employees of a listed company, these designated persons can be with respect to employees of a listed company or even employees of a material listed company. And sometimes if you feel that he is not an employee of listed company or a material subsidiary, he is an employee of a group company, but by virtue of his position, he has access to UPSI, then it is expected that we should cover them in the list of designated persons list. Obviously, it also says that support staff and IT staff and secretarial staff. Secretarial does not mean company secretarial staff. That is anyway, they have access to UPSI. This secretarial staff means personal secretaries, executive assistants, and all of those who handle mail, correspondence, meetings, etc. of the bosses, and they can also be considered, or they should be considered as a designated person. There are certain deemed to be designated persons, irrespective of, though there is no discussion with compliance officer or with the board of directors with respect to certain categories. That is, all promoters of listed company and promoters who are individual and investment companies in case of intermediary and fiduciary. So there is a segregation that in case of a listed company, all promoter, whether it is an individual or a body corporate, all of them, whether it is an investment company or any other company, all of them are considered as designated persons. Whereas when it comes to fiduciaries and individual promoters and only investment companies are deemed to be designated persons. All other promoters depends on whether the board of director and compliance officer wants them to be called as designated persons or not. Will all depend on that. Another deeming provision is the CEO and two level below CEO. They deem to be designated persons, not only for listed company, but even in case of SEBI intermediary and fiduciary. Even if you are listed company, even if the CEO and two level below the board, below the CEO, are considered as deemed to be designated persons when it comes to uh, listed companies, material subsidiaries are concerned, and whether they have access to UPSI or not, or whether they have ability to have access to UPSI or not, those questions are not relevant when it comes to that particular threshold. We need to remember that senior management under Companies Act is one level below this position, whereas here it is two level below CEO. And therefore, two level below CEO onwards, compliance officer is expected to track any new recruitment or any changes in that, so that they can update designated update depositories, that is ASPL or CDSL, and within 2 days, which we have been discussing again and again at several occasions. And they also we need to collate the data, considering them that they are the designated persons with respect to them, their immediate relatives, and so on, which we will discuss going forward. So, who decides? The board of director and compliance officer. But with respect to promoter, we have no choice. With respect to CEO, we have no choice. With respect to two levels below CEO, nobody has a choice. Position of promoter in case of a listed company. So, the question which which has raised by many in many cases is, if promoter does not have access to UPSI, if it does not discharge any functional role, whether he still will be considered as designated person or not. And this question we will discuss in the context of some of the informal guidances. But wording of regulation 9.4 appears to be very, very clear and unambiguous, that as far as promoters of a listed company are concerned, whether individual or a body corporate, all of them will be considered as designated person. Now, there is a distinction between promoter and promoter group under PIT regulation, and we all know promoter and promoter group, these are two different definitions. And promoter and person acting in concern, or acquirer and person acting in concern, are also two different definitions under SEBI SAST regulation and SEBI ICDR regulation accordingly, respectively. So promoter and promoter group are two different terminologies. Just to remind you that in somewhere in January 2019, SEBI regulations got amended, and Regulation 7 particularly got amended, where they said that not only promoter but even promoter group entity has to give a disclosure to the listed company about its current shareholding, and accordingly, many companies promoter group had disclosed. As far as this 9.4 is concerned, it only talks about promoter and does not talk about promoter group. So what will happen to that? That also we will see in some of the with the help of some of the informal guidance. Now, as far as intermediaries are concerned, the intermediary may be a listed intermediary, intermediary may be an unlisted intermediary. Here it is assumed that it is an unlisted intermediary. Then individual promoter and investment company, which is a promoter company, which is an investment company, those entities are considered as promoter group. So what is investment company and who is excluded from that? That is one question which was raised, and SEBI in its guidance note dated 5th July 2019 clarified that investment company will mean only those non-individual corporates. Now here it means non-individual corporates, so not necessarily be companies. It may be body corporate, it may be foreign company, it may be LLP. So investment company will mean only those non-individual corporates whose main object or principal activity is investing in securities or of other companies. For example, if promoter of a broking entity is a bank, then it need not be designated as DP. But if promoter is the investment company which holds investment in various companies, then it must be designated as DP. As we know, there are a lot of banks who have floated various SEBI intermediaries, maybe a broker, maybe investment advisor, so on and so forth. So all of them, they are saying that banks need not be considered as promoter, but other than bank, if you are an investment company, then you are necessarily have to be considered as a promoter. Now, when we discuss about investment company, and particularly in the context of principal activity of investment company, there are two definitions which emerge. Definition one is emerging from NBFC regulation, where they say that if more than 50% of assets and if more than 50% of income, if both of these conditions are from investment or financial nature, then you are considered to have principal activity of investment or principal activity of lending. Now here our question is principal activity of investment. So NBFC regulation says that both have to be more than 50%. Whereas 186 definition of investment company says that even if either is more than 50%, then that company will be considered as investment company. Now this happens typically in operating holding companies. So there are some operating investment which are holding companies, and many of those operation income from operations is more, but investments in assets which are of investment nature is more than 50% in some companies, where more than which are investing come operating holding companies. And in that case, even those companies can be considered as investment company. And now whether what is the principal activity of that company, that will be very, very relevant. And I think that this is a little gray area, and SEBI may come out with a guidance about what is principal activity, whether it should be 50-50 to be made by both asset and liability both, or only asset or only liability will also make it entitled as the investment company. Probably revenue may be the criteria from SEBI's point of view for determining what is the principal activity of the company. And therefore, if investment is more than 50%, logically speaking, SEBI would like to consider them as investment companies and just may not be on the asset side. Second question which comes is whether investment company would be interpreted as company or a body corporate, which I have already shared my view that even if you are a body corporate, but an investment body corporate, then it would be covered under promoter category for a SEBI intermediary. Now there was one informal guidance which was issued by SEBI on 1st of October 2019 in Apollo Trico Tubes, where what had happened is this company underwent a takeover process, SEBI SAST driven regulated takeover process, where one new promoter took over the company, or he took charge of management. However, old promoter continued to hold more than 10% shares, and because of which in LODR he continued to be called as a promoter category with respect to stock exchange LODR shareholding pattern disclosure. However, that a particular earlier promoter was not exercising any control, no role in management, not holding any position in the company. So therefore, he raised the question that can he be carved out of designated person list, and can he execute trades while window is closed? And then SEBI replied to him that promoters are designated persons de facto, and hence the person identified as a promoter is required to comply with code of conduct necessarily. And even if you do not hold any managerial position or otherwise, those promoters will be promoted. Once person is called as promoter, definitely he will be will have to be considered as designated person from a listed company context, and there is no choice with respect to promoters are concerned. Now, what happens with respect to so whether promoter group, what happens with respect to promoter group, whether promoter group is necessarily to be considered as designated person, or can they be kept out of designated person list? Now it appears, as I mentioned, regulation 7 specifically covers our promoter group, but regulation 9.4 does not specifically cover promoter group as a deeming designated person. So therefore, it would completely depend on case to case. And if promoter group entities are having access to UPSI, or promoter group individuals are discharging some key position in the organization, they are occupying some seniority position, then they will definitely will have to be called as designated person. Otherwise, the discretion which judicially one has to exercise, the discretion is with the CO, that is compliance officer, and with the board. However, once a promoter group is called by the listed company as a designated person, then what happens? So this is one informal guidance which was raised by one of the promoter group entity in Kirloskar Chillers. Now this was a guidance issued under 2017. The entity which raised question here appears to be from promoter group category and not from promoter category. Appears that there were two groups within Kirloskar family probably, and one of the group has said that we are in a promoter group category, but we do not have access to UPSI whatsoever. Neither we play any management role in the organization. Why should we be mandated for pre-clearance and all those requirements? Can we not be spared from pre-clearance? Because although our name appear in the designated persons list, which compliance officer and board of directors have done, but actually we are not designated. We do not have access to UPSI, and therefore we should be out of the purview of designated person and monitoring of trade and pre-clearance, window closure, contracted, all of that. They raised this matter to SEBI, and SEBI said that since promoters have felt it appropriate in consultation with compliance officer, that you should be considered, or you should be held as a designated person, and therefore SEBI would not want to interfere in the decision which is exercised by the board of director in consultation with compliance officer. And since you have been designated as designated person, therefore you have to comply with pre-clearance, contracted, window closure, all of that. So this is also very important guidance with respect to promoter groups. So we first discussed about promoter, whether he can be out. Then we discussed no, in a listed company, no option. In case of an intermediary and fiduciary, only individual and investment company. Then we looked at what is investment company and what can be probably SEBI's view with respect to which company can be considered as investment company. Clearly, SEBI's guidance note says of July 2019 that bank is not an investment company. You should be principal activity of that entity should be investment company, and then it will mandatorily we will have to be called as a designated person. Otherwise, it whether to call it as a designated person or not will completely depend on compliance officer and board. Then we looked at promoter groups distinction, that is promoter group treatment to promoter group given under regulation 7 and regulation 9, and applying mischief rule. Probably promoter group is not deemed to be promoter group entity need not be deemed to be designated person. It is the discretion of compliance officer and board. However, once compliance officer and board have discharged this judicial function judiciously, and once they feel that promoter group entity should be called as a designated person, then SEBI refused to interfere in this subject in Kirloskar Chiller's informal guidance. Now, once the person is a designated person, and if it is a natural person, then relative concept comes into picture. And who is relative? That definition has been prescribed under 2015 regulation. Under 1992 regulation, actually, they had relied on relative definition of Companies Act 1956, whereas in 2015 version of prohibition of insider trading regulation, they chose to define what is immediate relative separately. And under that definition, they say that person, the immediate relative means a spouse of a person. So spouse of a person probably appears to be necessarily a deeming immediate relative. And then further it said that and includes. So it is an exhaustive and inclusive both definition. Inclusive, exhaustive part says that spouse is exhaustively, it is undoubtedly immediate relative, whereas other relatives are concerned. Somebody has kept his mic on. Can Narendra, can you keep everybody mute? I think Rajendraji's mic is on. Narendra, can you do the needful? Okay, I will go ahead. So, so the question was raised in Manappuram Finance way back in 2015, where spouse was financially independent and therefore spouse argued with SEBI that I am financially not dependent on my spouse and therefore I should not be considered as a connected person and I should be out of pre-clearance requirement. But in that situation, SEBI had settled in the Manappuram Finance case in 2015, where they say that spouse with an independent income cannot, you know, yes, spouse with an independent income cannot trade without the spouse who is dependent. So that the designated person has to take a pre-clearance, and only then a spouse can trade. Otherwise, spouse cannot trade. And if spouse has traded without taking a pre-clearance, that is designated person has not taken the pre-clearance for the spouse, then the SEBI levied a penalty of 10 lakh rupees on the designated person and the spouse. So, very, very clearly, as far as spouse is concerned, there is no option. And we need to keep our spouse educated and alerted that don't deal in the share in these companies' shares, otherwise, I will be in trouble. So this is very, very important pronouncement. Again, with respect to immediate relatives, the pronouncements are concerned. In MCX technology, Parsham Puria was one employee of the company. Initially, this is a case under 1992 regulation, and this particular code of conduct which was adopted by MCX Technologies was little complex, and there were different thresholds for different employees. And so for officer category, it was a different compliance. For designated employee category, it was a different compliance and all of that. But that's not a subject of today. Today's subject is his father. So Parshuram Puria's father, Parshuram Puria himself also dealt and his father also dealt in the shares of the company. That individual employee who had dealt in the shares, he settled the case with SEBI. But as far as his father's trades are concerned, he tried to argue that, look, my father is financially independent. He is not dependent on me. And therefore, trades done by him should not be covered under code of conduct and no pre-clearance requirement should be applicable for the trades done by him. And he also argued that my code actually uses a different word and this bullet, third bullet, explains that company's code of conduct says that pre-clearance will be required for dependent parents, dependent children, and financial dependent relatives. So probably the employee appears to be very legal savvy wording, and then he took a view. Or at least he argued that, look, my parents are dependent on me, but financially not dependent on me. So maybe physically dependent on me, but financially they are not dependent on me, and therefore they should be kept out of this pre-clearance requirement. And SEBI said that your own declaration disclosure says that your father is dependent on you, and therefore we will say that they are immediate relatives, and we will be making them liable for the pre-clearance, so not taking a pre-clearance. And the penalty was levied of around 5 lakh rupees for with respect to not taking a pre-clearance for the trade done by the father. So father, if he is financially dependent and if you disclose him to be so, definitely there is a problem. Definitely he will be considered as immediate relative. Now, what happens to in-laws? That also we will see. And in-laws was subject was discussed in Nishad Gupta case, which was with respect to Diageo and United Spirits. So, in United Spirits acquisition by the Diageo, what happened is Nishad Gupta, who was a business development manager at Diageo, he also traded, and his in-law, father-in-law, mother-in-law, brother-in-law, all three Jashnani family, they also traded in the shares. And also there was a bank transfer of gains made by Jashnani family to Mr. Gupte indirectly through a bank of his wife. So therefore there was a hopping transfer. So whatever profits the Jashnani family made, they transferred it to their daughter, and daughter transferred it to Mr. Gupte, who was designated person of Diageo. What happened is that he claimed that they do not fall under the relatives definition of 1956 Act. because this case had happened in 1992 regulation of PIT. And as I mentioned, in 1992 regulation of PIT, for definition of relative, PIT regulations used to rely on Comparjac definition of relative. And he said that in-laws are not covered as relative for me. Whereas SEBI said that when we apply the same relative definition from the context of Jashnani family, and this particular case was with respect to Jashnani family's matter, and Jashnani family argued that for Mr. Gupte we were not immediate relative. SEBI said that for you, Nishat Gupte is a relative as per definition of Companies Act, and there was a money trail to say that whatever profits you made, you have transferred that money back to Mr. Gupte, and therefore SEBI claimed that daughter husband is covered in the list of relative for Jashnani family, and therefore they said that you are considered as connected persons, deemed connected persons. And thereafter, SEBI levied a penalty of 93 lakh on father-in-law, 1.31 crore on mother-in-law, and around 80 lakhs penalty on brother-in-law. This was a very recent pronouncement of 30th June 2020. Earlier, there was a judgment with respect to Nishat Gupte case. Now, there is a SEBI adjudication order dated 30th June with respect to their in-laws. So this addresses, this is clearly laying down a principle that whenever there is a financial dependency, financial linkages, and whenever the money has flowed from a connected person to his relative, clearly whether he is a relative, whether he is not a relative, all those questions, SEBI will find its own way out and establish that you are deemed connected person. Now there is one more case which comes to siblings, that is two brothers, real brothers. So that also we will see. Before that, there is one more important point here to be shared, that what is the scenario now under PIT 2015 regulation? Because as we saw, this was the case under 1992 regulation, where they were relying on Companies Act definition of Companies Act 1956 definition of relative, and therefore there was little confusion. Therefore, we need to see whether in-laws will be considered as relatives under 2015 regulation of PIT. And as has been elaborated here, the immediate relative definition here means a spouse of a person, so which is necessarily whether financially dependent or not, he or she would be considered as the immediate relative, and includes parent, sibling, and child of such person or of the spouse. And therefore, there was a lot of deliberation and discussion as to whether child of a person and spouse, or whether even it extends to parent and sibling of a person or his spouse. And probably if you look at Nishat Gupte case or Jashnani family case, I don't think SEBI will take a view that it is only that child of a spouse will be covered and parent and sibling will not be covered. I don't think that limited interpretation SEBI will take. And therefore, wherever parent, sibling, or child of your own, of that designated person, or of a spouse, if financially dependent on such person, or consult such person while taking decision, in both these scenarios, they will be deemed to be a connected person. Now, obviously, when a particular relative other than spouse, so father, sibling, or a child of the designated person or of the spouse, if that relative, immediate relative, if that immediate relative is not financially dependent on the designated person, then the discretion would always be with the designated person. And I don't think compliance officer has to investigate as to whether the list given is exhaustive or not, or whether the father or mother or brother or sister really financially dependent on this designated person or not. I don't think that kind of investigation is required from compliance officer. Whatever declaration he gives, I think he will be held liable for a wrong declaration if he has given. Now what happens is, let's say take case of sibling, that is a brother, who was financially not dependent on the other brother. And what happened to that? This is a SpiceJet case, trading. SpiceJet case, again, there was a trading which had happened in 2016, and SEBI adjudication order was passed on 30th June 2020, very recently. This was a matter of 2015-16, when on the third quarter of 15-16, suddenly the profits of SpiceJet jumped 300%, as compared to previous quarter. And during that period, in the month of January, this particular designated person and his brother both traded during UPSI period. And brother claimed that he is neither financially dependent on the designated person nor he consults designated person while taking a decision, while taking trading decision. But SEBI, so therefore it is onus on the SEBI to prove that I was in possession of UPSI. Because as we know, if the person is a connected person, then the burden of proof is on the person to prove that he was not holding UPSI. But when the person is not a connected person, then the burden of proof is on SEBI to prove that whether he was in possession of, he or she or it was, he was in possession of UPSI or not. And therefore, brother argued that I am neither financially dependent nor I consult to my brother. And therefore, I am not immediate relative, and therefore, I am not a connected person, and therefore, I should not be dragged. And if you feel, then you prove. So that kind of an argument went. However, then SEBI went in to examine the trading patterns of DP and his brother, and they found that there was a similarity with respect to the trading pattern. Both brother had bought the shares on the same day when DP had bought the shares, and brother did not sold the shares, but the SpiceJet employee had sold the shares. So SEBI held that both traded on the same day, and therefore there is a reasonable cause for us to believe that this was based on your brother's advice, who is designated person in SpiceJet, and therefore the penalty would be levied on him. And the total penalty levied was around 23 lakh rupees on DP, that is designated person, on 12 lakh rupees on the immediate relative. And probably how this matter went into surface is that compliance officer of SpiceJet had disgorged the profit which was made by DP, saying that it is a contra trade, and therefore he had transferred that profit to SEBI IPEF. And probably it seems that SEBI went deep into this subject and found out that not only he but his brother has also traded in the shares. And then they invoke so many provisions on their designated person. Compliance officer and company had levied a penalty of only contract trade and the disgorgement of profit, but SEBI levied several other penalties like trading in window closure, insider trading violation, and so on and so forth. So a lot of penalties were levied by SEBI on the designated person. And therefore, if you see, now when SEBI has come out with the prescribed format for reporting the non-compliance of code of conduct for a listed company to report to SEBI, they not only ask about the particular trade for which you are reporting this case, but they also ask you to report about any earlier non-compliances, and what is the consequence, what is the action which you have taken, and what is the reason for consequences. And therefore, if you see these pronouncements, we understand that why relative definition, which they used to rely earlier on Companies Act definition, why did they change to immediate relative definition in 2015, and why there is a clear cut demarcation between spouse and as far as non-spouse is concerned. So this comes very, so these pronouncements have been very thought provoking, and these have guided further amendments and further requirements. And therefore SEBI now expects compliance officers of listed entities, intermediaries, fiduciaries like me to report any non-compliance in this particular format, where you disclose his earlier trades. So what happens is, when all his earlier trades, you are expected as a compliance officer, we are expected to look at all his earlier trades and then see whether there was a window closed at that time, whether there was a contra trade at that time, whether there was a pre-clearance requirement at that time, which he has violated. And if you observe any non-compliances in past, a penalty will have to be levied on him. So this is as far as, even if financially independent brother got dragged into penalties by SEBI because they established that you are acting as per advice of your brother who is designated person from the trades, the pattern of trade between two relatives. So that's also one learning which one can take. Now there is a question of what is officer under SEBI regulation, because the word officer is still used under connected persons definition, which says that if you are in touch for last 6 months with the company or its officers, and therefore what is officer mean, that is the important question which still needs to be answered. This particular case which is appearing in the screen now, it's about one employee who was of ING Vaishya bank, and she had acquired some shares of ESOP and then subsequently sold those shares. However, did not made a disclosure under Regulation 13(4) of 1992 regulation. And she argued that I was not an officer because I was just the head of retail finance and I am not an officer. That's what her claim was. Now, what is officer? Officer is defined under Companies Act. At that time, they discussed about the definition of officer under 1956 Act. Similar definition is there is under even under 2013. So it starts with an include. So this is an inclusive definition. And she said that it includes a director, manager, secretary, or any person in accordance with whom, whose directions or instruction board of director are accustomed to act. Now, I am neither a director, nor a manager, nor a secretary of the company. And as per my instructions, board of directors are not acting. And therefore, I am out of the definition of officer. Officer does not include the simple officer which we use in dictionary meaning. That's what her claim was. So SEBI did not accept that, and Halsbury's law of England's dictionary they relied upon, where they said that any person who is regularly employed as part of their business or occupation in conducting the affairs of the company should be considered as officer. And there was one UK case where it was found, where it was held, their officer would include other persons in managerial position and does not exclude subordinate officers in the lower rank discharging managerial function. So therefore, anybody who is discharging managerial function should be considered as officer. This was one UK pronouncement which is of 1980, which was quoted by SEBI, and based on that judgment, SEBI said that you are an officer and therefore you should have disclosed under Regulation 13(4). Now, Regulation 13(4) is now not applicable to officer; it is applicable to limited extent. But the word officer is continued to be used in a connected person definition, and therefore anybody in touch with any officer of the company, officer means any employee who is at a little senior level to whom in this case, SEBI also argued in Gargi Dash case that look, you are head of retail finance and some 4 or 5 people report to you. Therefore, you are officer from our context. So SEBI levied a penalty of 4 lakh rupees. She appealed to SAT and SAT reduced that penalty to 1 lakh rupees. And in that discussion, why SAT reduced that penalty to 1 lakh rupees? SAT said that when she failed to make a disclosure, there is no proof that there was a loss to the investor. So that was ground number one. And ground number two was disproportionate gains which she has made could not be quantified. And therefore, there is no reason to levy a higher penalty. And whatever the minimum penalty prescribed under 15HB, that penalty was levied on a Gargi Dash by SAT, and only 1 lakh rupees penalty was levied. So from this case, there are two learning. One is officer word is still there under PIT regulation, and therefore we still have a relevance. And officer, many times this mistake happens of many professionals while reading definition. The word include is omitted, and just director, manager, secretary, or any other person in accordance with whose directions or instruction board of directors is accustomed to act. Just relying on that, she argued that I am not an officer, but it was rightfully argued that this is an inclusive definition and it includes a dictionary meaning of officer also. And to their help, there was one UK pronouncement where it said that even other managed person who are discharging managerial function, who may be at a little subordinate officers, but discharging managerial function should be considered as officers. So officer, and this particular why I mentioned about disproportionate gain is that Justice Dave's report, which recently we discussed in a couple of earlier sessions, which is submitted to SEBI. In that, there is a lot of discussion on how do you quantify profits made by a particular individual, and how do you ascertain profit and disproportionate profit. How do you ascertain profit? How do you ascertain profit was a discussion there, even in Gammon case, where its managing director had traded in the shares and SEBI relied on X day's price, and SAT asked them that why this day price, why not this day's price, and so there, the curious readers can always go on that subject, and therefore there is a discussion in SEBI that how do you quantify profit and disproportionate profit. There requires a clear-cut mechanisms for calculation of those profits, and soon probably SEBI will come out with those guidance also. Now, these are some of the penalties which we have seen in many of the cases. So 11(4)(b), which is about restraining from access of securities market. This particular section was invoked in India Bull Ventures and in Jashnani case of Jashnani, that is in-laws of Nishad Gupte. They have been restrained from accessing capital market. 11.4D, that is impounding order. These impounding orders we saw in PC Jeweler case and Dynamic Technologies case. Then in 11B, there is a disgorgement of profit, either saved, that is losses saved, or profits made. In either case, disgorgement of profit can be done. And this also we have seen IVL, that is India Bulls, then in Deep Industries and RICO case, RICO India also we saw. Then 15A, which is a failure to file a particular disclosure. This we saw. This also we had seen in couple of cases. Probably the Gargi Dash was 15A case, and then 15G is where there is a profit made. Where there is a clear cut dealing in while possession UPSI or communication of UPSI. In those cases, the penalty is minimum 10 lakh rupees or 25 crores or 3 times of the profit. And this we saw in Balareddy case, where the profit was made of around 14 crore and penalty was raised on around 40 crore. And Aurobindo Pharma case, where almost 3 times penalty was raised. And even in SpiceJet case, where this designated person had dealt, he made a profit of 1,76,000 rupees, but he was levied a penalty of minimum 10 lakh rupees. So 15G was invoked in that. And 15J determines what all are the parameters and factors to be taken by SEBI officer before levying penalty. And 15HB is jiska koi nahi uska khuda, section 450 of Companies Act, and 15HB, that wherever no separate penalty is mentioned, this is the penalty, that is minimum 1 lakh or up to maximum of rupees 1 crore. Now, this penalty also gets invoked with respect to violation of code particularly. So with respect to contra trade, pre-clearance, window closure, SEBI has been many times using 15HB. So these are all many sections which are available under SEBI Act, which help SEBI to levy penalty. Now, once somebody is considered as designated person, based on the earlier discussion, so we had a lot of informal guidance and pronouncements on this subject. Once what is the compliance which he has to do at the time of sharing? So before sharing, he has to enter into confidentiality agreement and or give a notice, confidentiality notice. He has to ensure that the information which he is sharing is fitting into the legitimate policy which is prescribed under Regulation 3 and under Fair Disclosure Code. And then he also has to follow the processes which are coming from Schedule B, Para 15, with respect to bringing people inside. While sharing UPSI, obviously he has to make entry in SDD, and if such person is an employee who is not a designated person, then compliance officer will have to add him as a designated person. And as I have highlighted last session, last Friday also, that SDD is mandatory not only for listed companies, but even for SEBI intermediaries and fiduciaries like me and practicing chartered accountants. So these are the compliances with respect to sharing of UPSI, and these are the compliances which designated person has to do with respect to, and his immediate relative, they have to do with respect to window closure, contra trade, pre-clearance. All compliance officers who are present here are aware about it, so there is no need to discuss this in detail. Just hold on. These are the compliances which compliance officer has to do with respect to collation of data and annual data, and whenever there is a change. So immediate relatives name, their PAN number, their mobile number, and the people who enjoy, the individuals who enjoy have material financial relationship with DP, their data has to be collated and updated from time to time. So this updation is very important. One-time data collation happens, but changes therein are not updated. And if there is no updated data, then companies can be dragged into penalties. And this also we saw in Justice Dave's report, which we had discussed a couple of Fridays ago, that companies who are not able to enforce, are not able to ensure that there is a robust mechanism to ensure that there is no leak of UPSI and to ensure that no insider and his immediate relative is trading, no designated person and immediate relative are trading in the share. That mechanism has to be there with the company, and if the companies fail to establish, or if the companies are not able to satisfy that, soon companies also may get dragged into penalties. This is the proposal under Justice Dave report. what is material financial relationship, that is also defined, and there is one informal guidance on that. So we will take that and then we can conclude for question and answer, Sunil ji. So what is material financial relationship is that a relationship in which a person is a recipient of any kind of payment from a designated person, such as by way of loan or gift, and during the immediately preceding 12 months. And if it is more than 25% of the annual income of a designated person, then that relationship will be called as material financial relationship. Payment on at arm's length basis will be excluded from that particular transaction. Now there was one informal guidance where GSPL had asked few questions. This was in December 2019. They asked few questions that if designated person wants to pay university fee for granddaughter by directly depositing it depository in university account. So they are not transferring money to grandson's or granddaughter's account, but directly to university account. Whether granddaughter will be considered as a material financial relationship. Second was if DP gives land as a gift, so not a money but land as a gift, whether it would amount to material financial relationship. Third was if DP repays financial obligation of a third person. So in all these questions, actual money is not moving from DP to the person, but there is either in the consideration is moving, the value is moving either in kind, or the money is moving not in cash directly to that person's account, but to some other person's account. So in university account or a lender's account, SEBI said that nothing doing, that you will be considered as having material financial relationship, whether monetary or non-monetary transaction, that is a value, so long as there is a value. Interestingly, there was a question raised in GSPL that if any maternal uncle of a designated person sponsors foreign trip of a designated person, cost of which is more than 25% of annual income of maternal uncle, then will it be termed as material financial relationship? And SEBI at that time had said that no, that will not be considered as material financial relationship, because that explanation of material financial relationship has undergone change, and that change now says that from a designated person to another person. So it is only one way. That designated person, when he gives money to somebody, only then that recipient is considered as designated, is considered as a person having material financial relationship. And that 25% has to be equated in the denominator is annual income of a designated person and not of the receiver. And here the question was, the designated person was a receiver, and therefore SEBI said that for a receiver there is no concept of material financial relationship. But I am sure that if that maternal uncle deals in the share while this person, designated person, is aware about some UPSI, then SEBI will definitely consider him as connected person for sure. This was all as far as designated persons and immediate relatives are concerned. We discussed about section 11.4b, 4d, 11b, 15g, 15hb, 15a. Three informal guidances: Apollo Tricord, Kirloskar Chillers, and the GSPL. And we also discussed about MCX Technologies, Nishad Gupte, which was a Diageo versus United Spirits, SpiceJet employees, Gargi Dash, which was the ING Vaishya Bank's employee, and Manappuram, where company itself settled the case with SEBI for leak of UPSI for rupees 2 crore rupees. And that's it from my side. I could finish it in 1 hour's time. Now we are
Excellent.
open for question answer.
Excellent. Excellent. Shall I come back on this?
Yeah, sure. You want to show your screen, or you are directly going?
Yeah, so actually we can start with the company with the QA, because there are some QA, there is some question, there are some questions already on chat.
Okay.
A person with whom a DP shares material financial relationship. Okay.
Then will he be treated as immediate relative? No.
Correct.
He will not be treated as immediate relative. He will be treated as a person with whom DP has material financial relationship. He's not an immediate relative. But this is a full. So let's understand that all the changes in 2019, be it with respect to HDD, or be with respect to tracking of UPSI, or be it with respect to compilation of data of DP, immediate relative, material financial relationship, and also the DP's ex-employers and DP's educational institutes and the years of passing. All of this is for inquiry and investigation. So whenever SEBI wants to investigate, or whenever compliance officer wants to investigate, then he should have this access, and therefore this is triggered. When Aarti asked this question that will he be considered as immediate relative? No, that means compliance officer need not track the trades done by those people, and neither those material financial relationship people are covered under code of conduct with respect to contra trade, window closure, or pre-clearance. So those obligations are not getting triggered for that particular individual. This is what SEBI's today's regulation stands as of now. They may change it at that time. It may change, but as of now, this is how it looks like. But if you are having material financial relationship with immediate relative only, right, then it's a different story. Then they are anyway immediate relative, and then it will be clearly financially dependence also. So, or so to say that you very, very clearly SEBI would say that he is immediate relative also and material financial relationship also. Then they will be definitely dragged into connected person, and I doubt whether financially I am independent kind of an argument, whether it will be accepted by SEBI in such scenarios. I think there was one more question. Also, are we required to track the transactions made by him? So I have probably answered this question.
Answered that. Yes, you did.
Yeah.
In the mean
case which we had discussed last Friday, which was Divi's lab case. This was incidentally with respect to CFO's son. From CFO's son's account, the trading happened.
Okay.
That is also one case identical to today's subject of whether dependent and financial dependent, and whether son will be considered as immediate relative. Now what happened is some of the employees of Divi's lab traded through Demat trading account of CFO's son.
Okay.
Now this was a very funny situation. So they didn't date in their own relatives or their own account. They did through CFO's son's account, and all of that got disclosed, and all of that got discussed in Divi's lab case where penalty was levied. And this was probably, we discussed that on last Friday, and that can also be one interesting case for anybody for understanding. And therefore, I think it very, very clearly relative, who's relative, my spouse relative. Wherever there is a money trail, and so in Parshurampuri also we saw, or in case of Nishad Gupte case also we saw that even if those in-laws were not under immediate relative definition for Nishad Gupte, who was a designated person, SEBI said that money trail is there, and so you are designated person's immediate relative, and therefore you are a connected person. Whereas in case of SpiceJet case, there was no money trail between two brothers, but both the brothers traded on the same day. Now the other co-brother, who was not a designated person, he argued that there was already a research report which was published in November that year, probably November 2015, which said that SpiceJet is going to have a bumper business in this quarter, and therefore I bought. SEBI said that if the research report you read in November, why did you bought in January when your brother bought the shares? And therefore your conduct goes to prove. And this is very, very important and vital for in any such argument, that what you say, what you write, what you speak, or what you argue, judiciaries would always look at the conduct and then conclude whether your conduct goes in line. Now this on the part of conduct also, I will again highlight the case of where one of the employees of Future dealt in the shares of when Future and Pantaloon demerger was happening, and that particular individual purchased the shares, and then he claimed that it was a mistake. And when he claimed that it was a mistake, he could demonstrate that, look, I wanted to buy GMR shares, and I was continuously acquiring GMR shares. When I placed an order on a technological platform, probably on a mobile app or something like that, he placed an order. And when he placed an order, in next 2 minutes, he realized that I have made a mistake. He placed a cross order. So if he has purchased, then he sold the shares. And then immediately in next, all this has happened in 3 minutes. that he placed an order for future. He placed an order cancelling, that is selling those shares, and he immediately placed an order for GMR. So he could establish his conduct that I was continuously buying GMR. This was an error which I observed immediately. I corrected, and when I corrected, I made a fractional loss. I didn't made a gain. That also goes in his favor. So his conduct is very, very. Many people ask me that क्या होगा, सेबी कैसे देखेगा, सेबी आर पार देखेगा. That's what I see.
Very true.
They see through, and then they take their call.
In fact, the whole point about that SDD creation is precisely to help SEBI have a track of whatever it is that is clearly being reported to the company, and as it should. If there is failure to report, or if there is incorrectness in reporting, both will get reflected in the system. And if there is, if there is no reporting at all, that also is very peacefully possible, because the moment you do not have reporting, and there is a Benpass statement that says a lot of things, the availability of data is today a huge benefit that aids SEBI. And also the fact that, they have imposed this requirement, and yet the requirement is not being fulfilled, the responsibility affixation also becomes easy, because you can clearly determine who is at fault.
Absolutely.
The fact that there is a SDD in place will enable the company and the company secretary to say, look, I am pursuing everything, but if a particular individual chooses to be silent out of an intention to do something different, then the company and I cannot be held liable, and therefore SEBI should look to that person for that particular problem.
Absolutely.
Okay, so my understanding of the situation is growing with time. Thank you very much, Mr. Joshi.
So there was one case which we did not cover. Where company secretary, she had resigned from the company. Okay, she was on notice period. And what had happened is company had announced a merger, that the company is going for a merger. They had made an announcement, and subsequently at one board meeting they decided not to go ahead with a merger. However, the intimation of the same was not given to stock exchange. While that decision was taken, company secretary sold some shares of her, and then the matter came to the SEBI, and SEBI said that you were aware about UPSI. She said that I had resigned, and the board meeting at which I was on notice period. I was serving my last 7-8 days during that period, and I was on notice period, although I was designated as the company secretary, and I did not attend at the board meeting. And then there was a chairman's and the management's letter that she was really not aware about this particular development. And then SAT said that, okay, we will pardon the penalty. So there are some such cases also. But I didn't wanted to highlight that case because I took that case as an exception. Otherwise, SEBI is generally very, does not believe in coincidences. And she does not believe, they want you to be whiter than white.
Correct. Coincidences are for the birds, as they say.
Yeah.
But
maybe we can conclude.
Yes, today I think we should, because we have made a large departure from the previous habit of being on Friday evening, which is clearly something that has probably not conveyed itself, or maybe we've not done as good a job as we probably should have. So next Saturday is probably something that we can look at, and we'll again, the subject for next Saturday is going to be trading plan. Correct me if I'm wrong.
Right.